1 week. That's all the time left before the man Trump handpicked to run the Justice Department sits down in front of the Senate and has to answer for himself. And I want to be upfront about where I stand. I don't think he should get through this hearing unchallenged. Over the next few minutes, I'm going to walk you through why, not with speculation, but with a track record. Here's the question every senator in that room needs to be asking. Is this a man who sees himself as the country's top law enforcement officer, answerable to the Constitution? Or is he still, in every way that matters, playing defense for one client? Because everything that's happened since he took this job points to the same conclusion. Loyalty to the president has consistently come before the independence the job actually demands. And in his own words, he doesn't see that as a problem. He sees it as something to be proud of. That's the case. Let's get into the evidence. So let's start building the record. And I want to walk through this chronologically because once you see these events lined up next to each other, the pattern becomes impossible to ignore. The first crack in the foundation came out of a federal courtroom in Tennessee. A judge there was asked to throw out a case entirely, not because the evidence was weak, but because the defense successfully argued the prosecution itself was an act of retaliation. That's about as serious as it gets in the legal world. A vindictive prosecution finding is rare. It's a formal acknowledgement that the government didn't just make a mistake, it weaponized its power against someone. And here's the part that should really stop you in your tracks. When given the chance to defend the case, to put the Attorney General himself on the stand and let him explain the department's reasoning under oath, the response was silence. No testimony, no defense. The motion to dismiss went through essentially unopposed. If you're confident your prosecution was legitimate, you show up and you say so. That didn't happen. Now move to Chicago. This is where things get even harder to spin. We're not talking about a defense attorney catching the government in a bad case. We're talking about federal prosecutors, the government's own people, walking back into court and asking judges to dismiss indictments they themselves had just secured. Multiple cases, multiple dismissals. And the reasoning wasn't a technicality, it was internal misconduct tied to how the grand jury process was being used. When prosecutors are voluntarily undoing their own work because the process itself was corrupted, that's not an isolated incident. That's a symptom of pressure coming from somewhere above them. And it doesn't stop there. Head north to Minnesota, and you find another round of dismissals, this time connected to testimony that turned out to be false and documents submitted to the court that shouldn't have been relied on in the first place. Different city, different case, same underlying problem, a Justice Department whose own submissions couldn't be trusted by the courts reviewing them. Here's why this matters beyond the individual cases themselves. The Department of Justice, historically, has operated under something courts call the presumption of regularity. Basically, judges start from the assumption that federal prosecutors are acting in good faith unless proven otherwise. That presumption isn't just a formality. It's the foundation that lets the entire system function efficiently, because courts aren't constantly relitigating whether the government is being honest. What we're watching now is that presumption eroding in real time. Multiple federal judges in multiple jurisdictions, over multiple cases, have reached the same uncomfortable conclusion. You cannot take what this Department of Justice says in court at face value anymore. That's not a talking point. That's coming from the bench. And when you step back and look at the sheer volume of this, a vindictive prosecution finding here, a batch of grand jury abuse dismissals there, false testimony and false documents somewhere else, you're not looking at a few bad days. You're looking at what may be the highest concentration of self-inflicted case dismissals in the department's modern history. Cases the government itself had to abandon, not because outside forces beat them in court, but because their own conduct couldn't survive scrutiny. That's the pattern. And it's worth asking. In an agency of thousands of career prosecutors, when this many cases start collapsing under the same kinds of problems, at what point does it stop looking like coincidence and start looking like culture? Because culture at the Justice Department starts at the top. Now, when a handful of critics start raising alarms, you can chalk that up to politics. But what's happening here isn't a handful. It's hundreds of people with no political axe left to grind, stepping out of retirement and out of their comfort zones to say something is wrong. Start with the judges. We're talking about roughly 300 former state and federal judges, including some who sat on federal appellate courts, who have organized themselves into a coalition. Retired judges do not typically band together and start filing briefs. That's not how the legal establishment normally operates. Judges, especially former ones, tend to stay quiet, stay above the fray, let the system work itself out. The fact that this many of them felt compelled to break that norm, to actively file motions and briefs offering guidance to sitting judges on how to handle an agency they view as out of control, tells you how seriously the legal community is taking this. And it's not just retired judges watching from the sidelines. Sitting federal judges, the ones actively hearing these cases today, have started saying openly in their own courtrooms that they can no longer extend the Justice Department the benefit of the doubt. That's a direct erosion of something the system has relied on for decades. The assumption that when DOJ tells a court something, it's true unless proven otherwise. When judges themselves start saying that assumption no longer holds, that's not a talking point from a critic. That's coming from the bench, from the people whose entire job is to be neutral. Then there's the third pillar of this backlash, and in some ways it's the most damning. Over 1,000 former Department of Justice employees, people who spent their careers inside this agency, who ran its divisions, both criminal and civil, at the appellate level and below, have signed onto a formal letter. Not a tweet, not a soundbite. A letter sent directly to the Senate Judiciary Committee, laying out their opposition to this confirmation. These are people who know exactly how the department is supposed to function, because they built careers making it function that way. When over 1,000 of your own former colleagues feel the need to go on record opposing your leadership, that's not partisan noise. That's institutional memory sounding an alarm. Put those three groups together: retired judges, sitting judges, and DOJ alumni, and what you have isn't a partisan pile-on. You have three separate, largely non-political constituencies, each with first-hand knowledge of how the system is supposed to work, independently arriving at the same conclusion. Something under this leadership has broken. Now, let's turn to something that's currently unfolding in a federal courtroom in Miami, because depending on timing, this could blow up right before the confirmation hearing even starts. A federal judge there is actively examining whether a settlement arrangement, one tied to events surrounding January 6th, was built on a foundation of deception directed at the court itself. That's a serious allegation. It's not a dispute over how much money changed hands or how a fund should be structured. It's a question of whether the entire legal vehicle was constructed as a kind of manufactured cover story, a mechanism dressed up to look like a legitimate settlement, when its real purpose was something else entirely. And what makes this worth paying close attention to is what that something else appears to be. Based on how this fund was structured, it looks less like a routine legal resolution and more like a broad shield, one that could extend protection not just to the president, but to family members and other unnamed associates, covering conduct both past and future. If that's an accurate read of what this fund actually does, you're not looking at a settlement. You're looking at an insurance policy against future accountability, built quietly, without the kind of transparency something this consequential should require. And here's what makes the timing so significant. The judge overseeing this could issue a ruling at any moment. There's a real possibility that finding comes down in the narrow window between now and the confirmation hearing itself. If the court determines there was, in fact, deception directed at it, that's not a footnote. That's a direct data point for every senator in that room. Because if the person now up for Attorney General had a hand in constructing something a federal judge is prepared to call fraudulent, that's not a side controversy. That goes straight to the core question of whether this is someone equipped to uphold the law or someone who's been actively working around it. Either way, expect this ruling to land right in the middle of the news cycle surrounding the hearing, and expect it to become one of the central flashpoints of the entire confirmation fight. At this point, you might be thinking, okay, this all sounds bad on paper, but is it really about loyalty over independence, or am I reading too much into it? So let's not just tell you, let's show you. 2 moments, back to back, that I think capture this entire dynamic better than any argument I could make. The first moment, a senator presses him directly about his past as the president's personal defense attorney, essentially forcing him to draw a public line between that old role and his current one. Watch how he handles it. There's a defensiveness there, an insistence that the two roles are cleanly separated, even as the questioning suggests otherwise. It's the reaction of someone who knows the association is a liability and is working hard to distance himself from it in real time. Now the second moment, and this is the one that really matters, in a completely different setting, with the pressure off, he's asked about his relationship with the president. And instead of downplaying it, he leans in. He speaks about the president in openly admiring terms, frames the closeness between them as something positive, even desirable, rather than something to be cautious about. There's no distancing here, no talk of independence, just open affection and loyalty, described as a feature of the job, rather than a risk to it. Now put those two clips side by side. In one setting, he wants you to believe the personal relationship is in the past, walled off, irrelevant to how he'll act. In another setting, with his guard down, he tells you the opposite, that the closeness is real and that he sees it as a good thing. That's the contradiction at the heart of this nomination. You can't have it both ways. Either the personal relationship shapes how he operates or it doesn't. And based on his own words, in his own unscripted moments, it's clear which version he actually believes. Now, let's talk about the issue that may generate the most questions of all in that hearing room, the handling of the Epstein-related files. Here's the basic shape of the problem. Despite mounting pressure and repeated promises of transparency, only a fraction of the total files connected to this case have actually been released. And the pattern behind that isn't neutral. It's marked by delay after delay, heavy-handed redactions, and a consistent failure to meet the production timelines courts have set. This isn't a case of an agency working through a genuinely complex document review. It's a case of an agency that appears to be actively slowing the process down. That resistance has already forced outside parties into court just to get movement. Multiple lawsuits have now been filed specifically to compel fuller production, and at least one of those cases has already produced a concrete deadline, a deadline that came and went with what can only be described as a minimal, insufficient response. Rather than complying, the message sent back to the court was effectively, "This is all you're getting." That kind of response, right before a confirmation hearing, is not a good look. It's a red flag. And here's the part that should trouble anyone watching closely. Despite multiple opportunities to explain this approach directly to a judge, under oath, in open court, that opportunity has been declined every time. If the reasoning behind withholding these documents were sound, this would be the moment to say so, on the record, where it could be tested. Instead, silence. And when the person in charge of an agency won't defend his own decisions under oath, that absence speaks louder than any explanation would. On top of the litigation already underway, there's now an additional legal front opening up. A separate public records request, the kind used specifically to force government transparency, has been filed to obtain everything the department holds, connecting him personally to this case, to the files themselves, to decisions around immunity or clemency for other figures involved, to custody and transfer records, and even to any contact tied to locations and judges relevant to the broader case. That request is still working its way through the system, but its existence alone tells you this story isn't close to over. Taken together, what you have is a pattern that should be very familiar by now. Documents withheld, deadlines missed, courts pushed to the edge of forcing compliance, and a refusal to ever explain any of it under oath. If there's a legitimate justification for how this has been handled, the public still hasn't heard it, because he hasn't given anyone the chance to hear it. So let's bring this all together, because when you lay every thread side by side, the picture becomes hard to argue with. A vindictive prosecution finding, with no willingness to testify and defend it. Multiple indictments collapsing because of misconduct inside the department's own grand jury process. Additional cases falling apart over false testimony and false documentation. Hundreds of former judges organizing for the first time to push back against an agency they view as out of control. Sitting federal judges openly stating they can no longer trust what this department tells them in court. Over 1,000 former department officials putting their names on a letter of formal opposition. A federal judge actively weighing whether a settlement tied to January 6th was built on deception of the court, with a ruling that could land any day. His own words, in his own unguarded moments, describing closeness to the president as a strength rather than a conflict. And now, the ongoing fight over the Epstein files, stonewalled, redacted, litigated, and never once explained under oath. Individually, any one of these might be dismissed as an isolated controversy. Together, they form a record. And it's a record that raises a legitimate, serious question. Is this someone equipped to lead the Department of Justice independently, or someone who has shown again and again where his loyalties actually sit? It's also worth noting that this isn't just a political fight anymore. There's now a bar complaint pending in New York, tied directly to this conduct, working through the process alongside everything else. All of this is exactly why this confirmation hearing matters, and why we're not going to look away from it. We'll be covering it live, gavel to gavel, with a pregame breakdown before the first question is even asked, and we'll stay with it through cross-examination. If you want to follow this story as it develops, make sure you're subscribed so you don't miss the coverage.